So let me ask you this, because this question comes up all the time. We've got a will. Somebody passes away. There was a will. So why can't we sell the property? There's a will. It tells it explains to everybody who is getting what.
Yeah.
Now, why would the title company have a problem with that?
Right, and I'm going to add another question to that. Why do we even have to probate? There's a will. It says I get the property. Why do we have to do that? And in some states you don't. In some states that would be enough and you can go on and sell the property. In some states there doesn't even have to be a will. They can sell without that. I have personal experience with that in other states.
Okay. But let's bring it back to California.
Yes, that's the key. Because people, maybe they grew up somewhere else and so then now they're applying that knowledge from that other state here. In California, a will must go through the probate process. So if a person dies and John Doe dies, John Doe has a property in his name. John Doe, let's just say an unmarried man, he's the owner of the property. If he's deceased, there's going to have to be some sort of court document that will allow someone to sell that property. If there's a will, if there's a trust, does not matter what estate plan they have. If the property is in his name, there's going to have to be some court matter there. Mm-hmm. So going more directly to your question, John Doe has a will, he died. Why does it have to? Because in California, we would have to have court documents to give someone the power to sell that property, and that's why you have to probate that will.
Okay. Now you mentioned the trust,
Mm-hmm.
and we see that a lot too.
Yeah.
Somebody gets a trust, family trust, they put the property into the trust,
Yeah.
they pass away.
Yeah.
So then, no probate.
That's correct.
What if they can't find the trust?
Then they have to probate.
Yeah.
The thing about trust, so when people, I've seen, I'm going to give a few scenarios. If you don't mind, I'm going to
go ahead.
give a few scenarios. So
because we've had this come up in the past.
all of these scenarios. Yes, you and I have had all of these scenarios. Okay, so they create a trust, but they never deed the property to the trust. So the property's still in Jane Doe, an unmarried woman, or whatever her title is. Well, it's like not having a trust because she didn't deed the property to the trustee of the trust. That's a problem. Another scenario, they deed the property to the trust. Everything's perfect. It's done right. Then they go to refinance later. They take the property out of the trust and forget to put it back in the trust. Well, the fact is, it's not in the trust. And if they die that way, then it's, again, not in the trust. So
again, probate.
Again, probate. And because there's a trust, they can do another thing that's called a Hegstead order. It's basically, Hegstead is case law that allows a judge to authorize the property to be in the trust based on this other case law. And so they can do that as a different procedure, so probate or Hegstead. Now, to go back to your scenario, they deed the property to the trust. It's perfectly in the trust. Everything's great there. But no one has a copy of the trust. I always ask people when they sometimes people argue. I mean, I'm just the messenger, right? It's like if the postman delivers an IRS lien, you don't punch him in the face because he said, you're giving me this. He didn't give you the IRS lien. The IRS did, right? So I kind of liken it to that. We're the one that comes and says, hey, we need a copy of this trust. And then they don't have a copy of the trust, and we're going to say, well, we can't insure a sale without having a copy of the trust. And I ask people all the time, okay, so who's the successor trustee? And they say, oh, I don't know. Or maybe they say, I am. Well, okay, prove that you are. The only way to prove it is to show us the trust that says, because the trust could say a corporation is they can put their bank in charge of being the successor trustee. The trust can say, I want my oldest daughter, or my youngest son, or my middle. We don't know. The trust can say whatever that trustor wanted it to say. So we won't know who the trustor is, what's supposed to happen with the property. We won't know any of that until we read the trust. Right. And I've seen scenarios where there's one child, but mom left 50% of her estate to the American Cancer Society or some other charitable organization. Well, that has to be accounted for. And so without seeing the trust, we don't know what it says. It's a private document. It's not a public record document. It is a private document. That trust is only where mom put the trust. If she, just to clarify, if she put it in her safe deposit, that's the only place it is. It's not like it's registered somewhere or filed somewhere, and that's the problem, is that we have to see the trust to know who's supposed to act.
You bring up an interesting point that comes up a lot, is when somebody tells us there is a trust and they can't find it, the first thing they're going to ask is, well, can we go back and see if it was recorded somewhere? So when somebody records a property in the trust, are they also recording a copy of the trust?
Okay, so generally speaking, no. Most people do not record their trust for a few reasons. Number one, there's a lot of private information in there. Social security numbers might be in there, bank account numbers might be in there, so most people don't record it for that reason. Even if they do record the trust, there's a challenging situation. So as a title company, we can get copies of almost all documents that record. But the way we get those documents, and I say almost all, the way we get a copy of those documents is because those documents post to a property. So if I'm recording a deed, for instance, that deed is going to have a legal description of a property and it's going to post to that property. So if I ever want to find a copy of that deed, it's very easy. At the title company, we look on our title chain, we put in that address, and it's going to pop up there. If I record a trust, it's not posting to any property. Most people don't normally put their legal description to